Hello everyone, and thank you for joining us today. Welcome to this episode of Instantly Informed. Today we're discussing the best practices when recovering from a cybersecurity incident. Today I'm joined by Mikel Pearce, Director of Business Development for North America, UK and Canada for CyberClan, Michael Martin, Senior IT Restoration Specialist at CyberClan, and Leonard Loewith, Complex Claims Director at AIG. So today we're going to be looking at one particular scenario. We'll be running this as if it were a tabletop exercise. So I'll introduce the scenario to you all, run through exactly what we'll be discussing, and then we'll take pointers from each of our panelists here. So the scenario today, we're looking at a manufacturing company that's been hit by a ransomware attack. Due to the attack, the production is offline and current daily business interruption losses are at $1 million per day. The company operates a just-in-time delivery model, so they're already behind on orders. So they're basically producing product and delivering as the orders come in. The organisation runs 3 shifts, 7 days a week, so they're essentially 24/7. They have customers across the US, Canada, and the UK, and keep banking and payment information of their customers on the file. They have 20 servers, all have been encrypted and are located in Canada, and customer data has been exfiltrated, affecting customers in all 3 regions. So, the discovery of this attack happened on Sunday morning by the CFO, who tries to log in from home after getting a notification that the manufacturing plant is down. The CFO calls IT when they're unable to gain access to the network. What happens next? So IT confirms that there is an issue and notifies the CFO that all the servers are down. The CFO then calls all the members of the C-suite that he has available on his mobile phone, including the CEO, CTO, HR, and General Counsel. So, General Counsel compliance states that the company has cybersecurity coverage as part of their insurance. Internal discussions ensue. HR, how we're going to communicate this with our employees. General Counsel, what's the privacy notifications responsibility? Does the organisation, does the organisation have any? CTO, we need to get the servers online as quickly as possible. CFO, what are the business interruption implications? What happens to the company if we have to pay the ransom? And the CEO, how do we get back up and running as quickly as possible? So the insurer is notified. Leonard, this is you. And Breach Coach makes contact with the ransom gang, who demand 5 Bitcoin per server, so 100 Bitcoin in total, totaling around about $2 million. So, Leonard, we've contacted you. We've found out that we have a cyber insurance policy. What happens next from your perspective? How do you handle this going forward?
Yeah, absolutely. I mean, unfortunately, very common scenario. And what we always encourage with our insurance is to take a little bit of a step back is that, essentially we as the insurer want to be your partner in handling this matter. And where we find that to be best is, either have us as your first call, kind of once the people internally have been notified. Either us as the insurer or the breach coach should be your first call. So some insureds will have response plans and things in place where they'll have a retainer with a breach coach set up ahead of time. If that is the case, then great, let's get that breach coach on board, your legal counsel to help you deal with this situation. If you don't have that, then absolutely reach out to your insurer. I know we have kind of a 30-minute response turnaround time on that 24/7, and I know many of the other carriers are the same. So we'll want to be notified right away. And if you don't have breach counsel in place already, then we will work with you to very quickly appoint breach counsel to get them in place. Really, the 2 things that we want to get set up as quickly as possible are get your breach coach or your breach counsel in place. I'll use those terms interchangeably. And then let's get out there and get kind of the forensics, IT, and remediation firm in place so that those parties can work with you all together to say, what's going on here? How do we get a handle on it? Broader investigation and figure out the next steps forward. That's kind of the general first step framework that we want to follow is, notify your carrier, get breach coach, and go from there.
So I think we can guess from the original layout of the scenario that they've found out they have cyber insurance. So I'm going to guess they don't already have a breach coach on retainer and it's someone that you have appointed. And also when it comes to post-breach remediation, Michael Martin will be looking at that side of things as well. So again, that would, it would be you that would appoint the PBR company and get them in touch with the insured, wouldn't it?
Yeah, absolutely. So we would certainly help, point them in the right direction as to particularly when we get a general framework of what it is that they're dealing with. We could say, these are the counsel that we worked with in these situations. This is who I would strongly recommend, and have a couple of names for them and try to facilitate that. One reason, at least particularly in Canada, that we strongly encourage get your breach coach in place immediately, and then the next steps is, to the extent that you're concerned down the road about any privacy litigation that could flow from things, having everything flow through your breach counsel or your breach coach immediately kind of gives you that protection of that solicitor-client relationship, some element of privilege, so that down the road, if you're looking in a lawsuit and saying, okay, did the company follow the proper due diligence steps, what was done? You don't have a whole bunch of internal correspondence just between people on the team that is potentially not privileged and could be disclosed down the road. You want to ensure that your communication, once it goes from the insurer to breach counsel, and then breach counsel and the insurer and the client together are working on appointing that forensics, that all is kind of covered off by that cone of privilege down the road as well.
I like that. So, Michael, as our resident breach coach, what would be your first steps with advising a client and getting in touch with the ransom gang?
So the first steps, is not to get in touch with the ransom gang. The first step is to contact the client and get your arms around the scope of the breach. As counsel, you need to understand what's happening to your client, what your client's concerns are, and what your client's objectives are in terms of recovering from the breach. So I actually had a breach like this while I was acting as breach counsel. We had a manufacturing company that went offline as a result of a ransomware attack, and they were losing about $1 million a day. And the CEO, there was some debate about paying the ransom, and at that point, the ransom in question was about $500,000, and he said to us, look, I'm losing $1 million a day, stop debating. And he used a very specific phrase, but he just said, stop debating and pay the ransom. So you really need to understand the pressure points on your client and on the insurer as well. But certainly there are going to be scenarios where you want to talk about whether or not to pay the ransom, but there are also going to be scenarios where you want to look at it and say, we're doing this right now. That was a few years ago, so we didn't have the hyper awareness of sanctions checks and the issues with Conti that have occurred in the last 6 months. So things did move more quickly back then. But certainly you want to make sure that you have your arms around the breach. You want to understand the scope of the breach, how much of your client's network has been affected, how encrypted is your client's network, do they have a backup, can they get restored from backup, or are they going to need to pay the ransom to get the decryptor key? All of those things go into the decision of how to approach the threat actor and whether or not you want to negotiate as a delay tactic or negotiate in order to end up paying all, part of the ransom at the very least. So the first thing is talk to your client. Second thing is get forensics involved, because as a lawyer, you don't have the ability to understand really the full scope of what's going on. You can understand it from a 30,000 foot perspective, and you can get a bird's eye view of what's happening to your client, but ultimately you're going to need forensics people on the ground who can look at the networks and say, this is the ransomware variant, this is the ransomware, we believe this is the ransomware threat actor, or at least this group, or the threat actors associated with this group. This is the kind of software that's being used that has been used to encrypt the client's network. And here's a basic understanding of how this threat actor group operates. So you want to have all of those things before you reach out to the threat actor. And in fact, usually it's not breach counsel who's reaching out to the threat actor. Usually it's somebody at the forensics vendor. The forensics vendor generally has ransomware negotiators on staff, and they're the ones generally who reach out to contact the threat actor through a Proton Mail account or some other disposable email account or other method of communication.
Excellent. So, Michael, with Michael Martin, that is, so basically, we're now on to initial discoveries. What does it mean? The insurance policy states that the company must cover half the ransom demand. So, Leonard, you and I just have discussed this previously. This is becoming more of a market, more common within the market, isn't it?
Yeah, absolutely. That was something that we really didn't see, I'd say, even 2 years ago. But I think with the massive shift to remote work that started in March 2020, and the large amount of cyber breaches that we saw as a result of that, that I know, speaking at least for AIG, I think all of our cyber policies moving forward have included an endorsement that's essentially a 50% ransomware co-insurance is the term we would use, that in the event that it is a ransomware incident, that in some cases the client would be responsible for half of the ransom payment. In other cases, that 50% would actually apply to the full quantum of the claim that comes from that. And I think that is just how the market is looking these days, and the recognition of the significant costs that were incurred on the cyber insurance side over the last 18 months to 2 years. That being said, if in a situation like this, where it's a manufacturer and there's clear quantifiable losses, as each day goes by, we would certainly be in consultation with breach counsel and with the insured as to whether or not they're interested in paying that ransom and pursuing that. That would very much be a collaborative discussion, and particularly where the client is potentially responsible for half of that payment, then we would very much be deferring to kind of what their preference is and what the advice of breach counsel and the forensics firm in terms of best way to get back up and running moving forward.
And I think that's one of the things that the company really needs to take a good look at, is how much cost are they incurring daily through business interruption in the first place? Mm-hmm. How much is the ransom demand? Can they afford to pay half? And also whether that business is going to be able to continue post-attack through any financial loss or reputational loss as well, isn't it? So Michael Martin, what would your first steps be when getting in contact with the company in question?
The first steps would be advising them to disconnect all, not power off, but disconnect all systems, because part of the forensics that will need to be gathered by the forensics team to investigate how the attack occurred lives in memory. So powering off a machine effectively erases that artifact, if you will, of how that attack occurred. So the first step is making sure they preserve all the evidence, essentially, to get to the bottom of how this happened to them, which also helps them in the recovery side of things to strengthen up that hole that existed, whether it be proxy shell exploit that it was recently used in Exchange, or 48 exploit and vulnerabilities. There's so many, obviously, and there's new ones every day. So it does help them recover and restore that network into a better state going forward. The next step would be getting a new network, considering everything in their current network is compromised. So they don't want to reintroduce any sort of malware or ransomware or something that's going to re-encrypt their systems as they're bringing them back online into their clean environment. So they need a clean environment to restore to, which is separated from their current system. So building a new VLAN, rescuing domain controllers, and whether they go with a decryptor or restore from backup, generally the best practice would be to build net new systems, whether it's domain controller or database server or what have you, and transfer the data over to those systems rather than just restoring a system state or decrypting a system and placing it back in production, because you can't effectively tell and trust those systems anymore. They've been compromised, so you don't want to rely on day-to-day use of a compromised system. Otherwise, you're just inviting this sort of incident to happen again.
Well, that's the thing, isn't it? The threat actor can leave behind malware and other
absolutely
things as well to gain access again, can't they? A
booby trap, if you will, maybe an infected file that someone might click on down the road. So we've seen them in GPOs where, when someone logs in, they run a logon script. So I mean, there's many ways that it can occur. So you want to make sure everything's clean and new. Then once that new infrastructure is in place, you can start restoring systems into it once they've been scanned and cleaned, and make sure any malware present has been addressed, and start bringing those critical pieces back online. Say they need to ship out, so they've got to get a database up that has their customer addresses, or they're linked to UPS, for example, or in any sort of system like that. So you kind of triage as you go, and bring back the critical pieces as fast as you can, and kind of move outward from that. So that kind of it makes it more of a bite-sized, stomachable piece that they can say, okay, this is my next step, and not everything's like, well, where do I start now? So you kind of build a plan as you go, and make it easier to manage.
So a bit like an earthquake, starting from the epicenter and working out.
Absolutely, yeah. In essence, it kind of was, because their whole environment is shattered.
Yeah, exactly. Brilliant. So we're now 3 days on. We're still in negotiations with the attacker. The post-breach remediation team are engaged by the insurer and have found that they will be able to restore from backup, which is excellent news. So we no longer need the decryption keys. The ransomware gang still has copies of the organization's data. So, Leonard, what would your advice be? We now know that they have exfiltrated data, they have copies of this data, but we're able to restore from backup. What are your next steps?
Well, first of all, seems like great news that we can restore from backup as opposed to having to decrypt or rebuild the whole system, etc. But what I would say is we would encourage the insured and forensics to continue those discussions with the attacker, even with no intention to pay a ransom or no need to, because we find that there's big value in kind of the information that you can try to get from the threat actor group. You can demand certain proof of life documents, even if we've been advised, yes, there's evidence of exfiltration and they have this, kind of stringing them along to get as much information as you can is very helpful. And then we really also defer to the expertise of the forensics, or if it's kind of a sub vendor under the forensics who are coordinating that communication, because what we find is it's an oddly small space. There are a number of threat actor groups out there, but they're, you know, the big ones are fairly well known. People have dealt with them in the past. And there's a small group of the forensics experts, or the folks who do the dark web monitoring and negotiations. And we really do rely on them pretty heavily for what their advice is. So if the information is, we can restore our systems and get back up and running, but it's clear that the ransom gang has copies of potentially sensitive information, how should we move forward? It's really helpful for us to know, you know, what's your experience in dealing with this attacker group in the past? Are they someone who, if you negotiate a ransom or you negotiate to pay, you know, they'll tell you what, dealing with this group, they always negotiate down to somewhere between 10 and 20% of the initial demand. So first of all, that's really helpful to know. But more importantly, and what clients always want to know is, if we consider paying this, are they going to destroy the data? If they're saying that they will undertake to destroy the data, is this something that they will actually do? Or in your previous experience with them, has this stuff resurfaced 6 months, a year down the road on the dark web somewhere? And you're never really able to give clients or us as the insurer any sort of definitive answer that yes, this information will be gone, but you have to basically rely on an honor among thieves system to say, listen, we've dealt with these people before. They send us some evidence of destruction. We've never seen it pop back up, because I mean, the threat actor groups know if they go back on their word in one case, then the next time this happens and they're dealing with the same forensic firm on the other side, they're going to say, no way, don't pay these guys. They don't keep their word. So it's a uncomfortable position for everyone, but you try to defer to the experts and get as much certainty as you can and try to make the best decision moving forward.
Brilliant. So there is exposure across all three jurisdictions, including Canada, the US and UK, including banking and payment information. What is your advice as breach coach, Michael?
So the first thing that you need to consider is whether or not you will have notification obligations and in which jurisdictions, whether or not you pay a ransom and you have some sort of assertion from a threat actor group that the exfiltrated data has been deleted. So there are varying regimes in place in the three different jurisdictions we are talking about here. Canada has, for the most part, a national regime, although certain provinces have specific regimes. So for example, if there's data that's been exposed in Alberta, in Canada, then the Alberta Privacy Commissioner has taken the position in the past that everyone in Canada will need to be notified of the breach. So you need to understand where it is that the people whose data has been exposed reside. Certainly in the US, you have different regimes state to state. So that's going to be a big mishmash of different reporting obligations and notification obligations. In the UK, you're under GDPR. So again, you have to understand what the implications and ramifications of that are. And you have to understand, whether or not GDPR will require notification based on this kind of attack and exfiltration. The safest answer is almost always yes, because if you answer no and you're wrong, then you face penalties or fines and ongoing lawsuits as well. So the reality is, in most cases, breach counsel are likely to advise that people whose information has been breached ought to be notified, whether there's a specific legislative obligation to do so or not. Now, obviously that varies jurisdiction to jurisdiction, and often varies based on litigation risk and what the potential downside risk of litigation might be in the various jurisdictions. And that does vary significantly by jurisdictions. So ultimately, when you're giving advice on a global breach like this, what you want to do is have associate counsel in the other two jurisdictions. So if I'm in Canada, I'm advising on the obligations, the notification obligations that exist in Canada, but you want to have associate counsel in the US and in the UK to give the insured advice on notification obligations that might exist in those jurisdictions as well. The other thing to consider is there are differing regimes and differing kinds of advice being given to lawyers in those three jurisdictions about whether lawyers in those jurisdictions can advise clients to pay a ransom. So for example, in the UK, there was a recent bulletin put out advising UK barristers and solicitors, or specifically solicitors, not to advise clients to pay a ransom. So I mean, there's ways to do that without actually specifically giving the advice. You can kind of leave that decision up to the client. You can tell them the risks, the downside risks of either decision, and leave the ultimate decision up to them, which is really what lawyers do anyway. They provide advice and then the client makes the decision. But ultimately, you know, the regulatory bodies are becoming more and more aware of this kind of thing and more cautious about what kinds of advice lawyers can give in these situations. So certainly there's been a lot more law enforcement involvement in policing ransomware gangs. There have been a couple of recent arrests, both by Interpol and by the FBI, which is certainly helping to tamp down ransomware activity. But that kind of legislative and international policing activity just has had an effect on whether or not counsel are comfortable giving advice as to whether or not to pay a given ransom. Ultimately, that's a decision to be made between the insured and the insurer. Obviously, counsel can weigh in on the pros and cons, but ultimately that decision often it's made by the client with support from the insurer and some advice in the background from counsel. But certainly, you know, you want to make sure that you're getting advice and providing advice to the insured from all three jurisdictions that are involved. And certainly you're not competent to do that unless you're called in all three jurisdictions. And I don't know too many people who are. So you need to have associate counsel in the other jurisdictions who are providing advice specific to the obligations that exist there.
Excellent. So, Michael Martin.
Yes.
Now that we know that we have backups in place that we can restore from, we don't need the decryption keys anymore. My question to you is, what sort of time frame are we looking at for restoring?
Well, whether you go with a decryptor or restore from backup, the timeline is generally the same, because you are building, like I said, building a new environment. You're building brand new servers and copying data over instead of restoring a system state backup. In most cases, I mean, there are some cases where there's a really old piece of software and it needs to be on a really old system. So we mitigate that as best as we can. Maybe isolate that system in its own VLAN, and limit the amount of traffic that goes in and out. So there are isolation techniques and mitigation techniques that we can use in that case. But regardless of which approach you take, generally the time frame is about 2 to 2.5 weeks to get to a majority functional state in the environment. Obviously, there are, like I had mentioned, like a triage mode that you can take, that you get the critical pieces of infrastructure in place, like your domain controllers, your database servers, and so on, mail servers and what have you. But to get to a majority state where everything's starting to fall into place, generally it takes about 2.5 weeks to get to that environmental soundness, if you will, where things are starting to hum along and your business is looking like pretty close to what it was before this incident occurred.
I think as well, some people believe the myth that you get the decryption key, you put,
yes,
you press the button and ping, everything's back up and running again,
right,
quick and easy as possible. But that really isn't the case, is it? Because regardless, you've still got to restore the system as if you're restoring from a backup anyway, just to make sure that you're restoring into that clean network and that they don't have that entry access back in again.
Absolutely, yeah. And there's also been times where the backup software used to back up the systems is very old, and no one had tested it before, and the software that was used to back up the systems was encrypted as well. So in one particular case, the company that made the software was sold to another company, and they no longer had the old version of backup software, so they had to go way back in their archives and to find a piece of software that was no longer on the shelf. And bits and pieces like that can really slow down your progress when restoring, whether it's from an incident like this or a system failure, hardware failure, what have you. So I think it is definitely advisable to do test runs regularly with backups and restores, and make sure everything works right, and have a plan in place to address something like this. It certainly makes it less hectic when things like this happen. So, and hopefully it's never used in anger, but yeah.
I remember hearing one case as well where the company had offsite backups, actual physical offsite backups, and hadn't gone to check them, hadn't checked the inventory on the system and made sure that everything was up to date. And when they came to restore, they realized that what the hardware that they did have in place wasn't actually compatible with the new system. And even though they had the backups, they had
there's tons
to go and sort all of that out as well.
Horror stories. In one case, we had a client that had an offsite cloud backup, and the threat actor had contacted the backup company and said, "Yeah, go ahead and delete all my backups. I'm good." And they followed through with it. Yeah.
Oh gosh.
So having some sort of disconnected offline, air gap system is definitely key in situations like this.
Yeah. Brilliant. So we're now 5 days on. The ransom gang has been notified that decryption keys are no longer needed. The gang threatens to sell the data that they have on the dark web and will tell customers what's happened. A reduced ransom has been negotiated to ensure the deletion of the stolen data. Now, Michael Pearce, I'd like to talk to you about the reduced ransom and the deletion of stolen data. How, from your point of view, is it worth paying a ransom to delete the data? If there's, they might be able to show that they've deleted the data, they might send a video to prove that they've done this, but there's no guarantees, are there, that data has actually been deleted and that it won't appear in 6 to 8 months' time?
So, no, I mean, ultimately the answer is no, there are no guarantees. And so what you really want to ask the client when they're thinking about paying a ransom for deletion is, what are you really paying for? And what are you going to tell your clients about what you've done? Because the first thing that a lot of clients are going to ask is, was a ransom paid? And if so, what for? And so you as a company, you want your client to understand what it is they're going to say to their clients about how they responded to the attack, and what they're going to say in justification of how they responded to the attack. So the first thing you want to talk to the company about is, do you as an organization want to tell your customers and clients, A, that you paid a partial ransom in order to ensure that their data would be deleted and not shared or sold on the dark web, and then tell them, oh, by the way, we're going to provide you with credit monitoring on an ongoing basis, just in case anyway. So you kind of lessen the effectiveness of saying we paid for deletion of your data. Well, if you paid for deletion of my data, why is credit monitoring necessary? And that's really kind of a belt and suspenders question. You're doing both things because you think it makes the client more secure. That's part of that story. The other approach, and some companies have taken this lately, is that they want to be able to say to their customers, we didn't pay the ransom because we think this is a criminal act and we don't want to engage with criminals. We don't want to negotiate with these people. We don't want to be paying ransoms because it just makes the problem worse. And so really that's a public relations question as to whether or not the insured company wants to be able to say to its customers and clients, we paid to keep your data safe, or we didn't pay the ransom because we don't negotiate with criminals. And so ultimately that is a corporate decision about how to position itself after or as the corporation emerges from this. And so if you're going to, for example, not pay the ransom, then you want to make sure you get out in front of that decision and make sure your customers and clients know that that's happening, and that you're going to assist them moving forward by providing them with credit monitoring or compensating them for any expense they incur in changing their banking data, for example, So you want to make sure that you look at that and weigh the costs of having to do that versus the cost of paying the ransom. And so really that it ultimately comes down to, are the costs of paying the ransom worth it from a public relations perspective, from an insurance perspective, from a corporate governance perspective, from a corporate responsibility and corporate reputation perspective. And you want to just make sure that all of those things go into the decision of whether or not to pay for quote unquote deletion of data. And also you want to make sure that you're considering the reputation of the threat actor you're dealing with. And of course, the problem with talking about that is you can, forensic actors, I think, will tell you that you can have an indication of who the threat actor group might be, but they're never sure anyway. Nobody is ever really sure who you're dealing with, where they're located. You can get a sense of, but based on the ransomware variant they're using and all sorts of other things, you can get a sense of who it is you're dealing with or which threat actor group you're dealing with, but you're never really sure. And it's the old saying, past performance doesn't indicate future returns. So just because this threat actor group has done A, B, and C in the past, that doesn't mean that they will do that again in the future. They may change their tactics. And that is one thing that threat actor groups are known for, is changing their tactics when their tactics don't work anymore. Mm. And so that's something that you need to guard. You need to ensure that your clients guard against and understand. In terms of whether it's worth it, ultimately that's a corporate decision. You can advise your client, that obviously and you want to make sure too, when the threat actor is saying, we're going to contact your customers and clients, show me proof of life that shows me that you actually have that contact information. Because it's one thing for the forensics team to say, we can see that X amount of data was exfiltrated. And it's one thing for the threat actor to say, we have all this information. They will always say that they have more information than they have. That's the game. So you want to make sure that the proof of life you get is indicative of what they actually have. And then you want to make sure that in consultation with your client, you understand whether or not they can carry through with the threats they're making about contacting your customers and clients. Some of them will be able to, and probably you'll know that pretty fast, because if you don't act in the way that they want you to, they'll start doing it anyway. So, that sort of thing you tend to find out more quickly. But you want to make sure you actually understand whether or not they can follow through with their threats before you pay them to not do that. So all of those things go into the decision. It is a very complicated process. Obviously, there's lots of decisions that are getting made in real time without the benefit of 2020 hindsight. So some things that happen in the course of a ransomware negotiation, if you look back on them, a month later, you might say, I wish we had done that differently. And that's why you want to do tabletop exercises with your clients. That's why you want to make sure that your clients and your insureds have run through these before, so they're not doing this for the first time, because you want to have them go through the experience once in a calmed situation, like a tabletop exercise, so that they understand how difficult this might be if it was real. And it's just like doing a fire drill. You start doing them when you're young, and by the time you're in high school, they're boring. Well, you're probably not going to get to the point where a ransomware attack is boring, but you want to get your clients to a point where they can make decisions in the middle of this crisis in an intelligent, thoughtful, informed way, rather than in a panic.
Yeah.
There are a number of questions in the chat.
Yes, I can see. We'll come to those in a minute. If we just,
right.
This is the last slide. So if we finish up with, so Michael, Martin, we've already sort of covered off the two questions on the end of this slide already, but we do have some questions in the chat for us to go through with you. So if we finish up, Leonard, with the final business interruption and ransom implications from your side of things as well. So, from an insurance perspective as well, you guys do really take into account business interruption, loss of business, and things like that as like really the key area when it comes to a ransomware attack, don't you? So could you talk us through that as the final stage, and then we'll go through to the questions that we've got in the chat.
Yeah, absolutely. And as you said, that really is a key part of the coverage to make sure you have in place. I think what we consider in our terminology to be our event management costs, which are basically you've got a cyber breach event, all the legal forensics, etc., even including the ransom sometimes to respond to it. Those costs are fairly predictable at the outset, depending on the scope of it, and don't vary all that much. Where the costs can get really significant for the clients is that business interruption piece, because the length of time in most of the policies is pretty standard, that you'll see 90 to 120 days of business interruption that's covered, sometimes as far as 6 months out from the breach. And depending on the scope of the coverage that you can get in place, that can cover not only loss of revenue or loss of customers from not being able to keep up with your obligations immediately following the breach, but most of our policy language as well even covers basically your internal payroll and costs moving forward for a period of 90 to 120 days. So depending on the size of the business, that can be a really significant expense. And, say you're shut down for 5 days and you're not able to operate, but you still have to pay your employees through that stretch, or you need to shift a huge part of your workforce over to responding and remediation. Or I've dealt with a manufacturing breach this year where it was pretty similar to the scenario that you laid out. And they basically had to go back to like paper and pencil and manning the phones to take orders and see what they could get out the door, and just significantly slowed down their process. So the cost from a business interruption standpoint can really balloon very quickly. The one thing I always encourage our insureds to do, and because, in the immediate aftermath of a breach, as Mikel alluded to, it's not the calmest scenario. You're not always focused on, okay, what's our insurance claim going to look like 6 months down the road? But to the extent that that someone internally is kind of tabbed as the keep your eye on the internal costs we're incurring, where are we shifting workforce? I know from my former days in private practice, when I was trying to do my billables the next day and say, what did I do yesterday? I could barely remember. When you're submitting an insurance claim 6 months down the road and you're saying, okay, who did we have to shift over and what were they doing in the week or two following the breach or the month or two? Trying to piece that information together down the road is really difficult. So to the extent that someone's trying to quantify that as the matter is developing, it makes it much, much easier to submit that business interruption claim, and makes it easier on our end to evaluate it and pay that out. I'd say the most complex parts of claim reimbursement are often around that business interruption, where no one's really tracked it. It's a little bit murky. So all the costs are submitted to us, and then we involve a forensic accountant firm to kind of work with them on that evaluation. So that, to the extent that insureds are prepared for and paying attention to that, that is really helpful on our end. In terms of the ransom implications, I know Mikel alluded to all the considerations you take into account. The only kind of major hurdle for us on ransom is often the sanctions regime that may be in place, and that really just depends on who you're dealing with. That one's constantly changing, so we'll rely on breach counsel to give us some kind of advice immediately before making that payment, just to make sure that it is actually something that legally we can reimburse you for. And that sanctions and compliance hurdle is sometimes the only thing that we run into. So often something that I'll flag right at the outset, and you kind of lean on your expert vendors that you have in place there to ensure that the groups you're dealing with are actually groups that you can make a payment to in the event that the insured decides to go forward with that.
Yeah, our last webinar looked at ransomware sanctions, and I was really shocked to realise that, it was pointed out to me that, you might look up the sanctions one day, make the payment, 3 days later the payment clears and the sanctions have changed, and you've now officially paid a sanctioned threat actor. And it's just the risk you take, isn't it, when you decide to pay the ransom? Like, at the end of the day, you can't guarantee that in 3 days' time things won't change, but it can take that long just for the payment to clear. And within that time, things can change, especially with everything that's been going on between Russia and Ukraine and everything as well. So that was actually a really interesting thing to learn from our last webinar. It had never occurred to me that could even be a possibility before. Mm-hmm. So Fantastic. Well, thank you so much, gentlemen, for joining me today. We do have some questions, so if I take us over to those now, and we can quickly run through those before we finish up today. So we have one here from Kevin. UK ICO warning on advising not to pay ransom is not binding. Is that correct?
I believe so, but I think the short answer, or the longer winded portion of that answer, is even if it's not binding, the warning is going to give a lot of people pause. So as much as it's not binding, it's certainly going to, I think, put a chill on what solicitors in the UK are prepared to say to their clients.
Okay, brilliant. Thank you, Michael. Tyler has said, would you trust decrypted data to go back onto production systems?
Ultimately, I would say not right away. There are steps we take to mitigate any risks that are relevant with that data. Usually what we do before moving that data into a production system is scan it with 2 separate malware scanners. We use a variety of tools. Microsoft Emergency Toolkit, MCSoft is another good one, and we scan that data twice before placing it back onto a clean system. That helps ensure that any booby traps that might exist in that data are effectively removed or filtered out. And secondly, which we include with most of our remediation engagements, a containment and monitoring solution, at least for 30 days, that monitors any systems that are placed in the new clean environment to make sure anything that kicks off, someone clicking on a file that's actually a PowerShell script that is going to try to re-encrypt your systems is isolated from the network and can't spread out to other systems next to it. So there are steps you take to mitigate those risks, but right away you follow through those steps and make sure it's clean.
Excellent, thank you. Tony has said, should insurance companies who provide cyber insurance set a mandatory list for their clients to have certain provisions in place, such as effective offsite backups, multi-factor authentication, endpoint detection response, and network segregation to successfully obtain a policy?
Yes.
Sorry. Len, you go ahead, and I'll
I was going to say, yeah, to speak to this, yes, absolutely. And I think that's the way things are going. I think 5 years ago, you got cyber coverage as a tack on to your regular D&O policy, and there were almost no questions about it. 2 years ago, you started to see kind of like these 2-page questionnaires when you're applying for insurance on just getting some information about your systems. And I would say today, the cyber coverage has moved to standalone policies where it's a very lengthy review process that our underwriters are going through. They will have very specific and pointed questions about what your system looks like, and oftentimes, depending on the answers to that, are choosing not to write certain risk just because of the way the market's looked the last couple of years. So I would say, Tony, absolutely, it's moving that way. And even for existing clients that we have with our cyber policies, we have something we call our cyber risk consulting services, which basically pairs our existing insureds with all of the vendors that we have on our panel list already. So whether that's breach counsel or forensics or folks like that, to do, tabletop exercises like this, to do a run through of your system and suggest improvements that can be made. It's very much now more of an active partnership between the insureds and the insurer on the cyber side, as opposed to, as I said, 5 years ago, where it was just a tack onto your policy that no one even really thought much of at the time.
Michael, did you have something you wanted to add to that?
Well, the only thing I would say is what insurance companies essentially price risk. So what insurance companies I think are doing, some insurance companies are essentially mandating that their clients have a whole series of cybersecurity protocols in place, or they won't write the policy at all. What that creates is an underclass of insureds or potential insureds who can't get coverage from those insurers because either they can't afford the security protocols or for any other reason. But what's happening, I think, is you have a certain cadre of insurers who are prepared to go in and write some of those clients. But what they do is they price the insurance accordingly. So it's a higher premium. They put in a higher self-insured retention. They sublimit certain things like ransomware payments. And so there are options available, but insurance companies are in the business of pricing risk. So if you represent a higher risk, you're going to pay a higher price for your insurance. It's as simple as that.
Excellent. Gary has said, as part of a good ransomware recovery strategy, would you recommend having pre-prepared PR statements for dealing with decisions around paying or not paying the ransom? So from my perspective as a marketing PR person, I would say yes. I would say sit down with the rest of the board of directors and work out exactly what your company's sort of, I don't know, what you are prepared to do in case of an incident like this. What is your messaging around it? Are you looking at, are you wanting to be clear and transparent with your customers? Do you want to be seen as paying threat actors, who could be funding terrorism? What exactly are you looking at going forward? And how do you want to deal with that? If at the end of the day, your company is on the line by not paying the threat actor, it needs to be something that you have thought about and are mindful of. And yeah, definitely pre-prepare statements, I would say. They can always be amended at the time. Michael, did you want to add something to that as well?
No, that's almost exactly what I would have said.
Okay, brilliant.
Louise, I'll just add to that quickly. One thing I know that's a very, very standard and is covered under the majority of cyber policies under that event management heading that I referred to before is also covers PR costs. Yeah. So there are PR firms, great to have internal stuff ahead of time. And then you can also bring in an outside PR firm that regularly deals with these types of breaches to give you specific advice on, here's our stance, here's the exact scenario, how do we word that to the public? 100%.
But, from a perspective of tabletop exercises as well, and looking at your own disaster recovery plan and things going forward, I do feel that it's always a good idea to have that in place and to understand where your company falls within that, what your moral feelings are around paying the ransom payment and who that payment may be going to as well.
Yeah, I think the scenario is to have both.
Yeah.
Yeah.
Adding on to that, I think having these things separated from your production network, i.e. not stored online, as well as your insurance policy, is a good idea ahead of time. I've seen cases where the threat actors have used that against their victim. I know they like to call them clients, but yeah, they will take this information and use it against you in a ransom and say, you've got to pay this much more because we know you can afford this much more. Your insurance company is going to reimburse you $5 million. We only want $2 million. So yeah.
Yeah, no, that's brilliant advice. George has said, does the company running the breach remediation provide the clean, disconnected environment to rebuild, or is this the responsibility of the client? Should that be part of the business continuity disaster recovery plan?
I think it would be great to include that in any sort of business continuity plan before any event happens, whether it's hardware failure or an incident like this, so forth. A lot of times that isn't always feasible, and sometimes even your BC site gets encrypted, by replicating across WAN or what have you. So that's not always feasible. We have, in some cases, provided loaner equipment to clients that they can start building new systems to restore to, at least to get them started, so they can grab the forensic artifacts off the affected systems and start to repurpose that equipment into the new environment. Most times, though, it is the responsibility of the client to acquire that equipment, and in some cases, I think insurance has stepped in and said your business downtime costs are going to far outweigh buying a new server that was heavily affected. Some cases it has gone to TA is so heavily damaged equipment in the attack that it's no longer viable. So new equipment has to be purchased, which has been a particular point of struggle in this post-pandemic world, with all the supply chain issues and whatnot. Trying to even acquire new equipment has been a huge trouble. Getting stuff back online. So there has been cases where that, which is where we stepped in some cases, and provide old equipment that isn't fit for using in long term, but at least we can get them back online and get them started.
I remember at the beginning of the pandemic, there was trouble getting hold of certain things when the production factories in China went down, wasn't there? So it was quite
absolutely,
difficult to get
yeah.
hold of hardware.
We're still seeing some of it, lingering effects. Getting new chips in from China even is still an issue.
Well, they're even still going through lockdown waves as well, aren't they, over there?
Yeah, so. Absolutely. They're kind of in a rolling lockdown, as it were.
Yeah, it's crazy, isn't it? We have two final questions left. We are going to run over time slightly, but they should be quite quick and easy to go through. So if we can quickly address them, then we can get these ones out of the way as well. So Tony has asked another question. Also, there are reports from the Law Society and Bar Council advising all legal firms not to pay any ransom. So we've sort of already covered that one, haven't we, Michael?
Yep.
With your earlier answer. And then Jack has said, in order to prevent business critical systems from being offline for too long, are powered off replicated VMs a safe and quick way to return to production?
Yes and no. You still have to keep those up to date and replicate to them in some sort of fashion, whether it's weekly application to a new VM or a offline VM, what have you. So there's still the chance of those being encrypted or affected during and before this incident occurred. A lot of times we see TAs will be in the environment for weeks or if not months before the event actually happens, and they say, oh, the system's offline. Oh, it's been encrypted. So a lot of times they'll lurk in the environment, they'll grab data, they'll plant booby traps. So you still, even if you have an offline replica of those VMs and those hosts, making sure they're still clean and safe, you would still want to rebuild those systems and put them into a clean environment to make sure that nothing untoward is in there, no malware, no booby traps, that sort of thing.
Excellent. Thank you so much, everyone, for taking part today, and all of our questions from our attendees as well. It's been an absolute pleasure. So if you do have any other questions post-webinar, we will be sharing the replay link on the website. I'll make sure to share the slides as well to accompany it on there as well. And we will be emailing the replay link to everyone who has registered for today's webinar. Next month, we will actually be taking a break. We won't be hosting a webinar due to the summer holidays. We all deserve a little break. But we will be back in September with our next episode of Incidentally Informed. So thank you everyone for joining me today, and thank you panel for joining me and walking us through this tabletop exercise. Thank you very much.
Thanks, Louise.
Thank you.
Thanks, Len.
Cheers. Bye.